And I would like to request Dr. Patil Madam to kindly propose the welcome. Patil Ma'am, over to you.
Thank you, Panchal Madam. Good
Thank
afternoon, everyone, and welcome to the national webinar for the Faculty of Law on Bhartiya Nyaya Sanhita, BNS. This webinar is initiated by Dayanand College of Law, Latur, in collaboration with Shri Shivaji Law College, Parbhani, Narayan Rao Chauhan Law College, Nanded, and Shri Shivaji Law College, Kandhar. At the outset, I welcome the Dean of our faculty, Dr. Parag Khadke, Dean of our Faculty of Humanities, and today's resource person, Dr. Shaifali Dixit, Assistant Professor, HP University, HP National University, Shimla. Friends, today onwards, we are going to take up we are entering into the new era of criminal justice system. Till date, I think my voice is lagging. I
No, ma'am,
think
it's
my
clear.
voice is lagging.
No, ma'am, it is clear, ma'am. It is perfectly okay. Hello, ma'am. Dr. Patil, ma'am,
Yeah,
you are
I
very
think my
perfectly
voice
audible,
is
ma'am.
lagging.
No, ma'am, it's okay. We are hearing
Is it
properly.
okay?
It's clear. Yeah, yes, ma'am. Yes, ma'am.
Okay, should I repeat it once again? Friends, today onwards, we are entering into the new era of criminal justice system. Till date, we were all acquainted with the age-old uh, generation, old laws enacted in the 18th century. I mean, it's lagging. I think it's lagging. Again, it is lagging. Could you please check the Could you please check the audio?
Yes, ma'am. I'll
Could
check
you
once.
please check the audio? Please check the audio.
Yes, ma'am.
Ma'am, it's audible to us. You continue. We can hear you, ma'am.
Yes, sir. There's no lagging. We can continuously hear you, ma'am.
Okay. As the generation Z generation is heading towards new era, to be welcomed, we as a career guide would take up the responsibility to properly convey the new challenges and new changes in the forthcoming future. Adapt, yeah, yeah. Adaptation of new things needs a mindset and acceptance. And for this, we have arranged a webinar to let us know the pros and cons of the upcoming new laws. Without wasting much of your time, I would like to request today's resource person, Dr. Shaifali Dixit, to please deliberate on the said criminal act. Thank you so much.
Thank you, ma'am, for a very frisk and a very affectionate welcome to a resource person. I would also like to welcome Advocate Shri Vajpayee, sir, member of CDC, Dan Law College, to this webinar. He is present here and a senior advocate of Latur. So his expertise and his guidance is always receiving, and under his guidance, all these programs are being arranged. I welcome you, sir. I would like to, before going to our resource person, I would like to really give a brief introduction to our today's resource person, Dr. Shaifali Dixit, ma'am. Ma'am is
Thank
recently
you, madam.
attended.
Thank you.
Thank you, sir. Thank you. We are
Thank
very
you.
happy, sir. You are joined here and giving
Yeah.
your precious time. Thank you, sir. Madam is at Himachal Pradesh National Law University, Shimla. She is working as the director of Center of Cyber Laws and Security at Himachal Pradesh National Law University, Shimla. Madam has done her LLB, LLM, and PhD from Department of Laws, Punjab University, Chandigarh, and she is having an enriching experience of 10 years And prior to joining the Shimla University, she has also worked at Army Institute of Law, Mohali, and LPU, Jalandhar. Her area of specialization is criminal law, forensic science, cyber crimes, and cyber security. Madam has been convener of various national and international conferences, national level moot court competitions, management development programs, and as well as faculty development programs. She has been to her record, she has published many and presented many research papers, almost more than 18 research papers, books, chapters in various national conferences, books, journals, etc. Madam is also expert in delivering various lectures as a resource person in various multidisciplinary projects, TOTs, like management development programs of Indian Army on cyber laws and forensic, training of prison officers in Himachal Pradesh on new criminal laws, etc. So these are just few I am giving. The madam has too many on her records. So she has also chaired various sessions and very international conferences at National Law University, Amity University, Noida, and Punjab University. So this is just a brief glimpse, ma'am. And today I'm very much sure that we have got a very valuable resource person to talk on this particular subject. So once again, I heartily welcome you, ma'am, and all the participants. And now I would like to give the charge to yourself and uh, request you to please share your thoughts on the topic. Yes, ma'am.
Thank you. Thank you so much for such a warm welcome. And my special thanks to Professor Dr. Poonam Nathani ma'am for inviting me here and considering me for this lecture on the newly framed criminal laws. So, starting with the lecture, first of all, can I please share my PPT on the screen and then we'll start?
Yes, ma'am.
All are requested to please switch off your cameras.
Ma'am.
Okay, so starting with the Bhartiya Nyaya Sanhita 2023, an overview. So on August 11, 2023, as all of us know, that the Union Home Minister, Mr. Amit Shah, he has introduced three new bills in the Lok Sabha. The Bhartiya Nyaya Sanhita Bill, the Bhartiya Nagrik Suraksha Sanhita Bill, and the Bhartiya Sakshar Adhiniyam Bill. So now these bills were introduced to replace the existing current three legal this legislations, that is the Indian Penal Code 1860, the Code of Criminal Procedure 1898, and the Indian Evidence Act 1872. On 18th August, the chairman of the Rajya Sabha, he consulted with the speaker and referred these bills to the Standing Committee on Home Affairs. And following their introduction in August, these bills were referred to a 31-member parliamentary standing committee headed by BJP MP Brijlal for review. So, after consulting the experts, the stakeholders, the panel has adopted its report on the bills on November 7th, with the opposition MPs pointing out several errors and recommending more than 50 changes.
Hello, ma'am.
Now, yes, am I audible?
Sorry to interrupt, but the presentation mode is not visible, ma'am. We can see the slide, but it's not in the presentation mode. Can you
Okay,
please?
okay.
Yeah,
Let me check what is wrong with
I think
this.
the tab has to be changed where it is being presented.
I can switch on the slides on my PC, but I think these are not visible to you, right?
Yes, ma'am.
Only the first one. Now is it visible?
In the presentation mode, it is visible. It is. We can see the slides also, ma'am, but it's not being
Okay.
presented.
Um,
Now you have shared the screen, your screen. If you share the screen, I think it'll be solved.
Now is it visible?
Yes, ma'am. Now it is visible. Now it is visible, ma'am. Yes.
Okay, okay. So
Thank you.
shall we continue?
Yes, ma'am. Yes, ma'am.
Now, talking about these three acts, however, the Prime Minister, Mr. Narendra Modi, he claimed that these three new laws, they will bring a tremendous change in India's criminal justice system. But if you see the point of view of the opposition leaders, they were not agreed with the same point of view. But however, these three acts of parliament, these were finally enacted as the Bhartiya Nyaya Sanhita 2023, the Bhartiya Nagrik Suraksha Sanhita 2023, and the Bhartiya Sakshya Adhiniyam 2023. And luckily, today only, as the government has notified that July 1st, 2024 will be the effective date for the enforcement of these acts, except few provisions. Now, if you see the enforcement date of these acts, so just 2 hours before, I was reading a news that the first FIR has already been lodged under this Bhartiya Nyaya Sanhita 2023. So now, when we are talking about the Bhartiya Nyaya Sanhita 2023, since because of the constraint of the time, today we'll only be able to discuss one act, right? This Bhartiya Nyaya Sanhita 2023. So starting with the changes which the Bhartiya Nyaya Sanhita has brought to the Indian Penal Code, because of which the whole act has been repealed and this new act has been introduced. First of all, focusing upon the title of this act, that is the Bhartiya Nyaya Sanhita. Earlier it was Bhartiya Dand Sanhita. So the difference between this word, the replacement of the word Dand with the Nyaya. So primarily, the government, the legislature, the parliament has claimed that now the act will be more focused upon the administration of justice rather than the merely sentencing or penalizing the wrongdoer or the offender. So I think this should be a very interactive session. So before moving forward, first of all, I would like to take your viewpoints. That do you think that after this implementation of Bhartiya Nyaya Sanhita 2023, the prime focus will be shifted to justice delivery rather than punishing the offenders? Any one of you? What is your viewpoint? And how it can be shifted by changing certain provisions? I hope I'm audible.
Yes, ma'am, you are audible.
You're audible, ma'am.
Okay, I'm audible, but I think I myself has to answer this question only. So as they have they have, uh, though they said that it will shift to the justice delivery system. So now it will not only means it will definitely it will focus on the criminal, but along with that, it will also focus on delivering the justice to the victims of the crime. Because you see, if the two parties we consider in a criminal case, that is always state versus accused, right? So when we talk about the victim, though victim is not a party but is the main stakeholder, or I will say the main person who has been aggrieved by the commission of that crime. But since we consider that crime is not against one person, crime is a wrong against the whole society, right? So in that case, though the state is a party, but we cannot ignore the rights of the victim, the restorative justice which has to be provided to the victim after the commission of the crime, and the rehabilitation of the victim as well. So now once we'll see the overview of this act, then at the end we'll reach to the conclusion that whether this Bhartiya Nyaya Sanhita is actually capable to do a complete or a comprehensive nyaya rather than merely punishing the wrongdoer of a crime. So the very first statutory change which has been made to the Indian Penal Code 1860, now renamed as Bhartiya Nyaya Sanhita, that is the alteration in the structure. If you see, inclusive of amendments and additions, Indian Penal Code is subdivided into 26 chapters that comprise of 511 sections. Now, 576 we can say when we include all the amendments and additions like the sections in the form of A, B, C, right? In contrast to the Indian Penal Code's convoluted structure, the Bhartiya Nyaya Sanhita has an improved structure having 20 chapters and 358 sections. But if we merely talk about the alteration in the structure, that could not be a sufficient reason to repeal the old act and to bring a new act. So definitely there should be certain technical changes that we are going to discuss at a later stage. 20 new offences have been added in the Bhartiya Nyaya Sanhita. 19 provisions that existed in the Indian Penal Code have now been deleted. In 33 offenses, the punishment of imprisonment has now been increased. Either increased or the form has been changed. In 83 offenses, the punishment of fine has been enhanced. In 23 offenses, the mandatory minimum punishment has been introduced, and in 6 offenses, the punishment of community service has been introduced. I would just like to show you a very brief this difference through a chart. This is a comparison chart. I hope this is visible on the screen.
Yes, ma'am, it's visible.
These provisions, which are in the bold letters, right? These chapters are related to the Bhartiya Nyaya Sanhita. And if you see this old provisions, or I will say the old chapters in the Indian Penal Code. So these are the major changes which have been done in the structure of the Act. The chapter 1, earlier it was chapter 1 was introduction and chapter 2 were general explanations. Now all has been concluded in one chapter, that is preliminary. Then the punishments. Earlier it was in the chapter 3, now it is in the chapter 2 of Bhartiya Nyaya Sanhita. Then the general exceptions. General exceptions were earlier in the chapter 4 from section 76 to 106. Now these are in chapter 3 from section 14 to 44. Then chapter 4 consists of abatement and criminal conspiracy in Bhartiya Nyaya Sanhita. If you see the old this Indian Penal Code, abatement, criminal conspiracy, and attempt to commit offences under section 511. Now all these are concluded in one chapter, that is chapter 4. Then the major change which has taken place from IPC to Bhartiya Nyaya Sanhita is related to the sexual offences. There is a new chapter, that is chapter 5 of offences against women and child, sexual offences, section 64 to 99. So then chapter 6 of offences affecting the human body, section 100 to 146. And all these were earlier contained in chapter 16 of IPC, chapter 20 of IPC, and 20A, that was cruelty by husband or relatives of husband, section 498A of IPC. Now all of them are clubbed in here in this chapter 5 and chapter 6 of Bhartiya Nyaya Sanhita. Then there are some other chapters where merely the shuffling is done, like chapter 7, chapter 8, chapter 9, and chapter 10. Now, if we talk about another major change that is in the end of this act, that is chapter 29 of criminal intimidation, insult, annoyance, defamation, etc. All of them are included from concluded from section 351 to 357. And finally, the chapter 20 of IPC has been repealed and section 358. So now, coming back to the technical changes which have been introduced through this Bhartiya Nyaya Sanhita. First of all, talking about the sexual offences. The first very major and a progressive change that has been brought by the Bhartiya Nyaya Sanhita is more stringent laws have been made on the sexual offences. First of all, if you see the section 69 of Bhartiya Nyaya Sanhita, that is sexual intercourse by deceitful means or false promise to marry will be considered as a crime under section 69. It will be punishable with simple or rigorous imprisonment up to 10 years and a fine. If you see the previous position of Indian Penal Code, so was there any crime related to the sexual intercourse by deceitful means or false promise to marry? Was there any such crime under Indian Penal Code? Though it was not specifically expressed as a crime under Indian Penal Code, but in the judgment of Anurag Soni versus the state of Chhattisgarh in the year 2019, the Supreme Court has outrightly said that making a false promise of marriage to have a sexual relationship would amount to rape. Though it was a Supreme Court judgment, but if you see, the provision was silent on this, so it was left on the interpretation of the court only. But now there is an express provision under Section 69 which has penalized any such act where a person does a sexual intercourse by deceitful means and by making a promise, or I can say a false promise, to marry. Then punishment for rape was already enhanced from 7 years to 10 years as given in Section 64 of Bhartiya Nyaya Sanhita, which corresponds to Section 376 of IPC. But if you see the earlier provision, Section 376 of IPC, it provided whoever commits rape shall be punished with imprisonment of either description. But now, Section 64 of Bhartiya Nyaya Sanhita, it explicitly states that whoever commits rape shall be punished with a rigorous imprisonment. So as I told you before, that either the punishments are enhanced or the nature of punishment has been changed. So now the Section 64 of Bhartiya Nyaya Sanhita clearly states that it will be mandatorily a rigorous imprisonment, not a simple imprisonment or not a punishment of either description. Then death penalty for gang rape of women below 18 years of age. If you see the old section, Section 376 DB of IPC, this section was basically introduced by the Criminal Law Amendment Act 2018, where Section 376 DB was introduced for the rape which is committed on the minor girls or the girls below age of 12 years. But now the age of the girl has been increased to 18 years. So there will be a death penalty for gang rape of women below 18 years of age as per Section 70 of Bhartiya Nyaya Sanhita. Then if you see the changing dimensions of anti-rape laws in India, see, we cannot say that only the Bhartiya Nyaya Sanhita is the act which has brought a change in the anti-rape laws in India. The changes have been introduced since few decades, I would say. If you remember the Mathura rape case, infamously known as Mathura rape case, the name of the judgment was Tukkaram and other versus State of Maharashtra. So in 1979, unfortunately, in this case, the Supreme Court has failed to mark a distinction between a helpless submission of a girl who was in a police station. Any one of you, if you know the facts of this Mathura rape case, if you can kindly share or discuss.
Ma'am, the question was regarding the consent.
Yes, yes, right. She was a minor girl. She was taken into police custody. And ultimately, these constables, they committed forced sexual intercourse on her. But in the as a version of defense counsel, he said that the girl is, because of this, at that time this finger test was permitted in for the rape victim. So finally it was concluded that the girl, though being minor and unmarried, is already habitual in having sexual intercourse, and secondly there were no injuries on the part on the body of the girl, so it means the girl was a consenting party. Unfortunately, the court has failed to draw a difference or a distinction between a helpless submission and a willful consent. And ultimately, the accused, they were acquitted. So because of this, 1979 Mathura rape case judgment, Criminal Law Amendment Act 1983, the case was also one of the major reasons which brought this Amendment Act, right? In which the consent and will issue was addressed. Then Sakshi versus Union of India in the year 2004. Sakshi was an NGO which has filed a writ petition in the Supreme Court of India regarding the rape cases, and it has also proposed that the definition of the rape must be widened. It should include all kind of I'll say insertions or all kind of penetrations. But after the year 2004, it took around 19 years for this legislature to actually widen the definition of the rape through this Criminal Law Amendment Act 2013. And how it came into the force? After the very unfortunate incidents of this Nirbhaya rape case in Delhi, as Mukesh and another versus State for NCT of Delhi. Now, the definition of the rape has been widened, but still there were few changes, or I would say there were few issues which remain unaddressed. Then in the year 2018, if you remember the Kathua rape case, small 7-year-old girl who has been kept in this religious place and has been kept as a hostage and was repeatedly intoxicated and brutally raped by a few men. Though it was in the introduction, as ma'am was talking about the hate crimes, so it was also a very very I'll say communal and hate crime, a grave example of that communal and hate crime, and which ultimately led to the Criminal Law Amendment Act 2018, which has inserted few other provisions in the Indian Penal Code related to the child rape. All these anti-rape laws have brought a tremendous change in the anti-rape laws or legislation in India. Now, talking about the Bhartiya Nyaya Sanhita, there are other few more changes which have been introduced by the Bhartiya Nyaya Sanhita. If we talk about section 72 of Bhartiya Nyaya Sanhita, a new law protecting the identities of sexual assault victims has been introduced. Now, if you remember this Delhi gang rape case, the name of the victim was not disclosed initially. She was called as Damini, Nirbhaya. Nirbhaya is also not her actual name, or some other fictitious names were given to her to protect her identity. The basic motive or the basic objective behind the protection of this identity or keeping the identity silent is to keep the rape victim protected from any kind of social stigma. But at a later stage, her parents said that since she was not at a fault, so they don't want to hide the identity of the victim, so they disclosed her real name, that was Jyoti. But actually, this law is otherwise necessary. It has to be the will, or it has to be the I'll say voluntary will of a person, of a rape victim or any sexual assault victim, that whether she wants to disclose her identity or not. Because of the social constraints, which we cannot deny, that still the victims of this sexual assault face at a later stage. Now, whoever prints or publishes the name or any matter which may make known the identity of any person against whom an offense under section 64, 65 or section 66, 67, 68, 69, 70, 71 is alleged or found to have been committed shall be punished with imprisonment of either description for a term which may extend to 2 years. So publication of the name without the consent of the victim will amount to a penal action, and that is a punishment which may extend to 2 years, and the person shall also be liable to fine. Then a new chapter, that is chapter 5, governing the offences against women and children, is separately included to cover all the offences against women and children. Earlier, there was a provision related to the importing of girls under age of 21 years for any illicit intercourse. This provision was related to human trafficking, right? So now, if a person imports a girl under the age of 21 years for illicit intercourse with another person, it was an offense. Now there is a small revision that has been done by a BNS, though the revision is small, but that is, I will say, a great change in the gender neutrality of the provision. Now this section 141 of Bhartiya Nyaya Sanhita, which corresponds to the previous section 366B of Indian Penal Code, which was only for the girls below 21 years of age. Now it specifies that importing boys under the age of 18 years for illicit sexual intercourse with another person will also be an offense. So it means now a victim can be a girl, the victim can also be a boy for the purpose of this human trafficking or for illicit intercourse. The only difference between the two genders will be the difference in the age. The girl below 21 years of age and the boy below 18 years of age. This could have a positive impact, as it is a way towards the equality in criminal law. I mean to say gender equality in criminal law. Then when we were talking about the Nyaya Sanhita instead of this Danda Sanhita. So this Nyaya Sanhita is reflected in this community service, which has now been added as a punishment, is provided as an initiative towards the reformatory measures of punishment. If you remember, earlier there was section 53 of Indian Penal Code, which provided 5 kinds of punishment: death, imprisonment for life, imprisonment of either description, forfeiture of property, and fine. But now, if you see the Bhartiya Nyaya Sanhita, section 4, which corresponds to section 53 of Indian Penal Code, it now has introduced one more kind of punishment in addition to these 5 punishments. I mean to say, along with these 5 punishments, that is death, imprisonment for life, imprisonment of either description, forfeiture of property, and fine, there is the 5th category of punishment, that is the community service. Now, community service is an unpaid labor that offenders may be required to perform as a form of punishment rather than being imprisoned. So now, in January 2024, I'll give you an example where the Goa bench of the Bombay High Court, they have directed a 2-year-old college student of Birla, 18-year-old college students of Birla Institute of Technology to undergo community service. Although it was not implemented, the act is now implemented, but they've set an example by giving these 2 boys a punishment of community service. And what crime has been committed by these 2 boys were that they have stolen certain items from the stalls on their college campus, like potato chips, chocolates, sanitizers, pens, notepads, mobile phone stands, 2 desk lamps, and 3 Bluetooth speakers. The lower court has given them a sentence along with the fine of 50,000 rupees, but the High Court has said that they should go and serve the community service. So now this has included in the Bhartiya Nyaya Sanhita itself. It has not been left on the interpretation of the court, but is included as a form of punishment in the Bhartiya Nyaya Sanhita Act. Again, for some other punishments, like a public servant who violates their legal obligation to refrain from conducting trade will be subject to simple imprisonment up to a year, a fine, both, or community service as given in section 202 of Bhartiya Nyaya Sanhita. Again, for another offense, that is section 209, it provides imprisonment for a term which makes 10 to 3 years, or with fine, or with both, or with the community service for non-appearance in response to a proclamation under section 84 of Bhartiya Nagrik Suraksha Sanhita 2023. Means if a person is not appearing in response to the proclamation done under section 84 of Bhartiya Nagrik Suraksha Sanhita, he or she can also be awarded with the community service for non-appearance rather than awarding a sentence or fine or both. Then again, there is another provision that is related to theft, right? Section 303 subsection 2 of Bhartiya Nyaya Sanhita provides that whoever commits theft shall be punished with imprisonment of either description for a term which makes 10 to 3 years, with fine, or with both. And along with this, the community service is also prescribed as a mode of punishment. Then, if you remember this Mental Health Care Act, which has specifically come to protect the persons who are punished under section 309 of Indian Penal Code. Section 309, that was attempt to suicide. Now, attempt to suicide was partially decriminalized with after legislating this Mental Health Care Act, for which the persons who were suffering some mental health issues prescribed under Mental Health Care Act, they were not sent to the jails for the imprisonment in case of attempt to suicide. Now, section 226 of this Bhartiya Nyaya Sanhita has provided another alternate, that is the community service as a punishment or 1 year imprisonment. So it is an alternate, it is not the only punishment, but it is an alternate. Either the community service or 1 year imprisonment can be given as a punishment for the attempt to commit suicide. Then section 355 provides punishment of simple imprisonment of up to 24 hours or with fine, or with both, or with community service for misconduct in public by a drunken person. Now, this misconduct by a public in public by a drunken person is again a very common problem which we face in the public, right? There's so many people who create lots of hue and cry and misconduct in public once they are drunk. So instead of sending them to imprisonment, they can also be given a reformative method, that is community service. And lastly, the defamation. For the offense of defamation, community service is again an alternate punishment provided under section 356 subsection 2 of Bhartiya Nyaya Sanhita, which can be given as a punishment for defamation. Then the most controversial section of this Bhartiya Nyaya Sanhita, which invited lots of protest in the country, specifically by the truck drivers, by the, I'll say, heavy vehicle drivers. That is section 106, causing death by negligence. If you remember the old provision of Indian Penal Code that is related to death caused by negligence, section 304A. Now, section 304A, which corresponds to section 106, which corresponds to section 304A of IPC, has made much more stringent. It consists of two subsections. The first one is whoever causes death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with an imprisonment which may extend up to 5 years. Shall also be liable to fine. And if such act is done by a registered medical practitioner, he shall be punished with imprisonment of either description for a term which may extend to 2 years and shall also be liable to fine. First of all, it has been divided into two categories. Death caused by negligence by any person, death caused by negligence by a medical procedure or a medical practitioner, right? Now, death caused by negligence by any person, the maximum punishment can be 5 years. Death caused by a medical practitioner while performing a medical procedure, because of negligence, if the death has been caused, the punishment can be up to 2 years. Now, this is an initiative, first of all, which has been taken in the medical jurisprudence to deal the cases of medical negligence under criminal law expressly. We can't say that earlier they were not dealt under criminal law. That is why I'm saying explicitly. Now it has been specifically mentioned that death caused by a medical practitioner, but the punishment, if you see, there is a difference in the punishment. The punishment for the medical practitioner, the maximum punishment is lesser than the punishment prescribed for the other persons. There is a reason. If you remember the case of Jacob Matthew versus State of Punjab in the year 2005, and Suresh Gupta versus Government and City of Delhi in the year 2004. These are the two very, very landmark judgments related to the cases of medical negligence, right? So, in the case of Jacob Matthew, the Apex Court has supported the medical practitioners. Why I'm saying has supported? Because the Apex Court, if you see the wording, which is on your screen as well, there is no personal gain of such medical practitioner in acting negligently or by omitting to do a rightful act. Therefore, court must be very vigilant while ascertaining the blame of negligence on the medical practitioner. Now, if you see the next line, this line is very much, I will say, logical, rational, emotional, but yet causing a little harm to the interest of the victim who has died on the hospital bed because of some medical negligence. If you see the wording of the court, because a surgeon with shaky hands under the fear blameworthy legal action cannot freely perform a successful operation. So the court is always of the viewpoint that medical professionals should be dealt with utmost care while ascertaining their criminal liability. Because if they will be having a fear in their mind that I can be criminally held liable for the operation I'm conducting in case the patient dies, they won't be able to perform those procedures, I will say, with the full confidence. So that is why the court said that it has to be dealt with utmost sensitivity and utmost caution. They must not be blamed for medical negligence in most of the cases. Then if you see the Suresh Gupta versus NCT of Delhi, the three parameters, the three situations have been set by the Supreme Court where only the liability of a medical practitioner will arise, otherwise not. If the doctor is not skilled, if for that particular treatment, if the doctor is skilled but he refused to give that treatment, if the doctor is skilled but he did the treatment in such a manner which was manifestly negligent. So the 304A was confined in the context of medical negligence by the apex court judgments. But now, if you see the current position, it has been expressly dragged or inserted under section 1061. Now talking about 106 subsection 2. I have underlined this subsection 2. There is a reason, because it was the provision which has attracted maximum controversy and protest throughout the country regarding this Bhartiya Nyaya Sanhita. Moreover, this one, only this section 106 subsection 2 is the only up to the extent of subsection 2 is the only provision which is not implemented from today. Because after their protest, the government has come to a conclusion, or the government has promised them that this particular provision will not be applicable without the due consideration or discussion. This provision is related to the rash and negligent driving. Whoever causes death of any person by rash and negligent driving of vehicle not amounting to culpable homicide and escapes without reporting it to a police officer or a magistrate soon after the incident shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Now the cases of hit and run, specifically on the highways, where no one is the witness, no one knows who has done this accident, whether the person was negligent or not. The punishment has made very, very stringent. Rather, the nature of offense has also been, changed or has been transformed. So in such a situation, they have done a great protest that it will be very difficult for us, because usually because of mob lynching or because the people attack on us, we have to leave that place of accident first of all. Secondly, whosoever might be wrong, but as a notion, generally the person who is in a heavy vehicle is considered to be the wrong one. These were their arguments, because of which they have started the protest, and ultimately the government has said that okay, this subsection 2 will not be implemented before the due consideration and discussion. So that is why they have taken back their protest. Now another controversial provision that is related to sedition. Provisions under the sedition laws are retained under section 152 of this Bhartiya Nyaya Sanhita. But if you see the bare language of the act, the term sedition has now not been used. So sometimes it creates a confusion or a misconception in the mind of the people that the sedition has now been removed from the newly framed act. It is not so. Just few changes have been done, otherwise the sedition law is still retained. It provides whoever purposely or knowingly by words, spoken, written, signs, visible representation, any electronic communication or use of financial mean or otherwise. This otherwise is very much comprehensive in nature, subject to the interpretation, may include so many other means. Excites or attempts to excite any kind of secession, armed rebellion or subversive activities, or encourages feelings of separatist activities. This feelings of separatist activities is again a new term which has been added in section 152. Or indulges in or commit any such act shall be punished with imprisonment for life or with imprisonment which may extend to 7 years and shall also be liable to fine. Now, the previous law on sedition attracted a lot of controversy because it was contended that it still contains, though it was amended, but it still contains the old draconian this mentality or implementation of the British colonial rule. So now the provision has been transformed, but still there is a question that the newly formed law on sedition, once it will be applicable, whether it will be a protective provision in nature only, or it may amount to the violation of the freedom of speech and expression of the people. This electronic communication means is the newly added this phrase in the provision, and All these new acts, that is armed rebellion or subversive activities, encouraging feelings of separatist activities, endanger sovereignty or unity and integrity of India, these are all newly enacted terms. These are certain major key differences which have been introduced under Section 152, the law of sedition. Then there are certain other progressive changes which has been introduced by the Bhartiya Nyaya Sanhita. There was no term related to terrorism and terrorist activities which was there in the Bhartiya Nyaya Sanhita. Though we are already having certain acts which are related to terrorist activities, exclusive acts, right? POTA, Prevention of Terrorist Activities, right? But those were not expressly mentioned as a crime in the Indian Penal Code previously. But now, if you see the Bhartiya Nyaya Sanhita, Section 113 of the Bhartiya Nyaya Sanhita, it contains terrorism and terrorist activities defined under the law for the first time, and it will be regarded as an offense. The terrorist activities will be regarded as an offense under Bhartiya Nyaya Sanhita. Then again, another new provision, that is snatching. Section 304, whoever commits snatching shall be punished with imprisonment of up to 3 years and shall also be liable to fine. This snatching offense was not in the Indian Penal Code. Then a very new category of organized crimes. If we talk about organized crimes, what do you understand by these organized crimes? Any one of you? Have you heard about these organized crimes?
Ma'am, where a group of people are involved, alone it cannot be done, ma'am.
Right.
Individually
Alone
it cannot be done.
Right. And can you give any example of an organized crime or the group of people who are committing organized crime?
Smuggling,
Exactly.
Dacoity,
Even rackets, different human
arms
organs
dealing,
transportation.
Yes, rackets for human trafficking, this smuggling of any kind. Then, if you take the example of this Mumbai underworld mafia, they usually, these rackets, when we are talking about these organized crimes, they work in a very, very organized structure. By organized structure, I mean to say that most of them have designated roles, though illegal, but very designated roles. And all of them, they commit crimes in continuity. By continuity, I mean to say that not only once, that once the kidnapping has been done. No, we hero hai. These are the rackets. They will do these crimes continuously, repeatedly, and in a very, very structured form, in which each and every person will be having a specific role. Specifically, when we talk about the cross-border crimes, smuggling is an example of this cross-border crime. Organ trafficking is an example of cross-border crime. Human trafficking is an example of cross-border crime. Recently, rather I will say from last 1 decade, not just recently, the skin trade, I mean to say the outer skin of the people is taken for this plastic surgeries, and this has also become an organized crime because now it is taken without their consent, specifically from Nepal. So now all these kinds of organized crimes, the people who are involved as a group of person acting in a concert, singly, jointly, either as a member of an organized crime syndicate or behalf of such syndicate, by use of violence, threat of violence, intimidation, coercion, or any other unlawful means, everything will be included in organized crime and can be penalized under Section 111 of Bhartiya Nyaya Sanhita. Then Section 112 of Bhartiya Nyaya Sanhita further describes petty organized crimes. These are less severe in nature, but still done in a group or a gang, either singly or jointly, but in continuity. So, for organized crimes, the punishment, if such organized crime has resulted in the death, the punishment can be imprisonment for life or minimum fine of 10 lakh rupees. Otherwise, for any other injury, the minimum punishment for 5 years, and which may extend to imprisonment for life and minimum fine of 5 lakh rupees. So the people who are working in girohs, they should be beware now. And then petty organized crimes like theft, snatching, cheating. Maybe they have these, I will say, proper groups or giroh. They do it very systematically. unauthorized selling of tickets, unauthorized betting, gambling, selling of public examination question papers, any other similar criminal act. The imprisonment for 1 to 7 years, that is the minimum punished imprisonment will be for 1 year and the maximum can be for 7 years and will be accompanied with fine. Then another very common problem, most of us have seen that if we see a person lying on the road who has been a victim of any accident, or specifically a person who has been a victim of sexual assault, such people when taken to the hospital, कई बार क्या होता है, these victims are in a very I will say vulnerable situation and a very serious medical condition. But the doctors, they refuse to treat the patients before this MLC is done. Medical legal case is filed and they say, let the police come, only then we'll be able to treat the patient. Or sometimes they say, we don't want to indulge, specifically the private hospital. Sometimes they say, we don't want to indulge or drag ourselves into any kind of this police action or this court kacheri ka chakkar, so we are not going to treat this patient. So for this reason, punishment for non-treatment of victim in section 200 of Bhartiya Nyaya Sanhita has been given, which is a newly introduced section, was not there in the Indian Penal Code. Whoever being in charge of a hospital, public, private, run by a central government, state government, local body or any other person, contravenes the provisions of section 397 of Bhartiya Nagarik Suraksha Sanhita shall be punished with imprisonment for a term which may extend to 1 year with fine with both. Now let us see what is this section 397 of Bhartiya Nagarik Suraksha Sanhita. It clearly states all hospitals, public or private, shall immediately provide the first aid or any medical treatment which is required free of cost to the victims of any offense related to rape, acid attack, and be under BNS and sexual assault under POCSO. Means all these victims will be immediately treated and must be treated free of cost by the hospitals, either private or public, any hospital. Then this is another offense which has been introduced. We say mob lynching. The term mob lynching has not been expressly inserted in the Bhartiya Nyaya Sanhita. But if you see section 103 of Bhartiya Nyaya Sanhita, that is punishment for murder, and subsection 2 of 103. This subsection 2 of section 103 contains the elements of mob lynching. When a group of 5 or more persons acting in concert commits murder on the ground of race, caste, community, sex, place of birth, language, personal belief, or any other similar ground, each member of such group shall be punished with death or with imprisonment for life and shall also be liable to fine. So here we need not to fulfill the conditions of the previously this enacted section 34 common intention of the Indian Penal Code. Merely presence in such a group, acting in concert, if a murder is committed, each of them shall be equally liable. Then, talking about this, these are all the changes which have been introduced by the Bhartiya Nyaya Sanhita, and that is why the Indian Penal Code has now been repealed and the Bhartiya Nyaya Sanhita has been enacted and has become operative from today itself. But now talking about the shortcomings, or I will say the limitations or the challenges which are still unaddressed or unheard or unresolved even after the implementation of Bhartiya Nyaya Sanhita. Before discussing these challenges, first of all, I'd like to take your viewpoint, your opinion. What do you think? Do you feel that there are still certain areas in the substantive criminal law which are still unaddressed?
Ma'am, this particular section doesn't mention the ground of religion.
Okay. Race, caste, community. Community, I guess it can contain, definitely you are right, it will subject to the interpretation of the code.
But
as religion is the most common reason.
But if we are referring constitution refers religion, but this particular section is not mentioning religion. Why that has been deleted?
Yes, you are right, it has to be expressly mentioned. apart from this provision, mob lynching, any other these lacunas that you find in the Bhartiya Nyaya Sanhita, or you still feel there are certain areas which have remained unaddressed? Any other kind of offense or any change in the criminal law? Because we are saying now this is a very tremendous and a very, very progressive change that will be brought. So all the issues which were existing till date has to be resolved, at least addressed, if not resolved. So do you feel that there are still certain areas which are unaddressed or unresolved? Okay, so this means all of you consider that now this is a perfect substantive criminal law without any imperfection or without any further area which need to be inserted, changed, amended, or included. Then I might be having a different opinion, because I still feel, and if you see the recent, I will say, the discussions on Bhartiya Nyaya Sanhita,
Ma'am, the
many
definition of
people
rape
from the,
is hello. Am I audible?
yeah. Yes, you are audible. You are talking about the definition of rape.
I mean, the it is not. I think it's biased towards women. I mean, it does not
Okay.
include
Yes,
male
you are
or
raising a
boy.
very, yes, your point is well taken. You are saying that the definition of rape is still gender biased. It is not gender neutral.
Neutral.
So, do you think that
No,
it should be
even
made
I
gender
think,
neutral?
excuse me, ma'am, even I think that
Yes.
cruelty is more required to be more gender neutral, because cruelty from wife to husband, whether it is covered or not, is also it depends on the interpretation. Rather, it should be gender neutral, because such
Very
cases are
nice.
also
Very
there.
nice. So now, first of all, we are pointing out the gender neutrality of certain provisions, right? One of our participant, he has rightly said that the definition of rape is still gender specific. I won't say biased, I will say gender specific. Only a man can commit a rape on a woman. We have not included any other gender as a victim. And secondly, as ma'am has said that the other participant, that the cruelty, when we talk about the offense of cruelty, merely the provision has been shuffled. The wording is exactly same as it was given in the section 498 of IPC, and it still only contains the cruelty done by husband or his relatives towards the wife. It's still not covering the both of the spouses. However, if you see the family law, if you see the this civil action, definitely the civil law accepts the cruelty by husband as well as cruelty by wife as a ground of divorce. But in the criminal law, the criminal liability is still limited to the husband or his relatives. Agreed. Your point is well taken. Any other
Ma'am, I feel
shortcoming?
sexual harassment at workplace. That is also not the gender neutral
Right.
section, ma'am.
Sexual harassment at workplace under the Sexual Harassment Act, right? Sexual harassment at workplace act is gender neutral. So which kind of sexual harassment are you talking about? Specifically the sexual harassment provision in this Bhartiya Nyaya Sanhita.
Yes, ma'am.
So if we talk about the provisions related to sexual harassment, if you remember the Criminal Law Amendment Act 2013, 4 provisions were added, right? Stalking, voyeurism, this sexual harassment, and this. So now 2 of them have now become gender neutral in this Bhartiya Nyaya Sanhita. But still, outraging the modesty of the women is still gender specific. We are still sticking to the age-old notion that only the modesty of a woman can be outraged. There is no modesty of a man specifically that can be outraged. So for that point, I can take your point that this is still we will say a point of criticism. Okay. Any except this gender neutrality point, any other provision that you think in the Bharti? Because we have discussed all the changes. Trust me, once you will read the Bhartiya Nyaya Sanhita and Indian Penal Code comparatively, you will realize that today we have discussed all the changes which have been brought. So any other?
And section
Yes.
152, that is, I mean, in new sedition section, include the word otherwise. That is not specifically defined.
Yes.
But
And
I
this will
mean,
attract
then the police authorities will have wide power. I mean, there might be
exactly.
chances of harassment.
Exactly. That is why I specifically said when I was talking about that provision that this sedition provision, the word, this otherwise, it is very wide very wide, very comprehensive in interpretation, and it may curtail our freedom to speech and expression. And moreover, it may be misused to, I will say, satisfy the political interests. Okay. Any other change or any other thing? Your voice is not audible. Though I think you are saying something, but it is not audible to us.
So हे म्यूट है ना माझा म्यूट है ना माझा म्यूट
सर माइक म्यूट करा विजय सर.
If you want to ask question, please go ahead.
Yes, anyone? So now talking about the implementation and practical challenges in certain unaddressed issues in Bhartiya Nyaya Sanhita 2023, which we can say a way ahead. First of all, decriminalization of unnatural offences. If you remember section 377 of IPC, I was eagerly waiting for this response also. Section 377 of IPC, agar aapko yaad ho, unnatural offences. It was partially decriminalized by the judgment Mate Singh Johar versus Union of India, Ministry of Law in the year 2008. It read down section 377 and decriminalized same-sex relations between the consenting adults. But still, the portion containing the non-consenting adults or the consenting minors, it was still a criminal offense. Moreover, any kind of unnatural sex with animals, it was still an offense. It was still an offense under Indian Penal Code. But now, if you see the Bhartiya Nyaya Sanhita, the section 377 unnatural offences has been completely deleted. So now, if we talk about section this unnatural offences and rape, parallelly. So as one of you have pointed out that rape is still gender specific. Only a man can commit rape on a woman, right? So in that case, if any man commits rape, or I will say any forced sex on another man, because now each and every kind of penetration is included. So it might be an anal penetration, it might be a penetration through any object. And such kind of tortures are very, very common in prevalence. So in such a situation, moreover, if any person commits any forced sexual intercourse on a transgender, if any female commits any kind of forced sexual penetration on another female with any other object, in such a situation, there is no crime under IPC. Specific crime, no specific crime under this Bhartiya Nyaya Sanhita. So, since there is no specific crime under Bhartiya Nyaya Sanhita, either it will go for grievous hurt if some injury is caused, but if no injury is caused, then what? Then it might be a sexual assault, but the punishment is very less. So, in such a situation, the decriminalization of unnatural offences has ultimately led to the deletion of section 377. But such kind of, and moreover, if a person commits unnatural sexual intercourse with an animal, so these has to be well dealt under Bhartiya Nyaya Sanhita, but somehow have remained unaddressed. Secondly, when we are talking about the expanding the horizons of rape, as you have said, if you remember this judgment, Independent Thought versus Union of India, exception 2 to section 375 in Indian Penal Code, so far as it relates to a girl child below 18 years, is liable to be struck down on the following grounds. Now, if you remember, in this particular case, it clearly said that this particular exception 2 must be struck down or must be deleted. The reason being is that, sorry, the reason being is that it was considered to be violative of Article 14, 15, 21. Because because there was no logic that if a person is committing a forced sexual intercourse with a wife below 18 years, 18 to 16 years, then it will not be an offense. And if the female is not a wife, then it will be an offense. So in such a situation, this particular exception has been deleted by Bhartiya Nyaya Sanhita. But what about the criminalization of forced sexual intercourse by a husband on a major wife, the wife who is above 18 years of age? Bhartiya Nyaya Sanhita only penalizes the act of forced sexual intercourse by the husband on his wife if they are living in separation. But if they are not living in the separation, if they are in cohabitation, then what about the consent of the wife? If she is forced to have sexual intercourse with the husband, there is no, the major question is whether the marital rape can be criminalized or not. Though there are practical challenges. There are practical challenges because it is very difficult to identify the consent or no consent between a husband and wife. And if you go by an age-old notion, which simply states that marriage itself is a willful consent throughout the life for the sexual intercourse. Thirdly, if you see the laws related to marriage under these family laws, under these personal laws, where the consummation of the marriage is an essential of a marriage. So in such a situation, on one side, we can say that a marital rape cannot be criminalized. But on the other side, what about the human rights of that female who is forced to a sexual intercourse by her own husband in her own house? What is your viewpoint? Do you think that marital rape should be criminalized or not? Yes, anyone? क्या लगता है आपको? Whether the marital rape should be criminalized or the same situation must exist in future as well?
Ma'am, I think as a law, as a criminal law, we should have the facility, we should have the provision, of course, a properly defined provision, so that
Yes.
to avoid the misuse also. So only to
Yes,
address the
you are
problem.
right. Because yes,
Because when we
yes, because if we include it in the section of rape itself, then it will be misused. So you are absolutely right. There should be a separate provision with separate conditions, separate essentials. Not should be combined with the offense of rape, but there must be a separate provision.
Yes.
Now, talking about making rape a gender-neutral offense, as one of you has stated. If you remember the judgment of Priya Patel versus State of MP in the year 2006, Apex Court has clearly said that after reading 375 of IPC, rape can only be committed by a man. Apex Court has not said that rape can only be committed by a man. Apex Court has said that Section 375 constrains us in such a way because this is a penal provision. Penal provisions पे कौन सा rule? Which rule of interpretation do we apply? That is the strict rule of interpretation or the literal rule of interpretation. So in that case, Section 375 clearly states that a man can commit a rape on a woman only. Say, now the Bhartiya Nyaya Sanhita offense of rape, it again states that only a man can commit a rape on a woman. So we are not saying that a man can commit rape on another man. A man can commit on a trans rape on a woman can commit rape on a man, or a woman can commit rape on a transgender, or a transgender can commit rape on a transgender. We are making it so gender specific in a very tight water compartment. And now this 377 is also being deleted. So now this is an area of concern that what about the forced sexual penetrations by any other gender on other genders except by a man on a woman. Then talking about dowry, rape, cruelty, compounding of offenses. Any one of us, I guess, has pointed out that the cruelty is not a gender neutral offense. You are right. It can be because the reason is that a wife can also commit a cruelty on a husband, and in that case, she has to be penalized equally like a husband. But another area of concern regarding these dowry, rape, and cruelty is the false accusations. And if sometimes it is very clearly seen that the woman is actually being harassed by the husband, or she drags some other family members from the in-laws as well, which were not directly involved, like this sister of the husband who is living at a very remote place, the husband of the sister of this husband who has never visited the house to commit any kind of cruelty, but out of revenge or out of the feeling of that enmity, negativity that has arose in her mind due to this harassment, she drags each and every person. Now, the irony of the fate is that these offenses are non-compoundable in nature. At a later stage, even if she changes her mind, the two parties cannot come for the compromise because the offense is non-compoundable. Secondly, if the nature of the offense, that is a cognizable offense and moreover non-bailable. So once the people are arrested, it is subject to the discretion of the court that whether the bail will be granted or not. So they will be behind bars until and unless the bail is not granted, right? And they can be arrested immediately even without a warrant. So to avoid such situations, there came a judgment, Rajesh Sharma versus State of UP in the year 2007. And it was held in this judgment that there should be a district family welfare committee, which, as long as the parties agree, may reach to the settlement. This district welfare committee and this district welfare committee will be having equivalent powers of a district court only. But now there arises a technical question of law that in a non-compoundable offense, where only the High Court has the power to quash the proceedings under Section 482 of CRPC, can an authority equivalent to the powers of a district court make that non-compoundable offense compoundable itself, merely because the parties agree? So in such a situation, there came another judgment, that is Social Action Forum for Manavadhikar versus Union of India in the year 2018. Within 6 to 7 months, this judgment came, and the Supreme Court immediately modified its previous decision taken in the Rajesh Sharma and clearly said that the duties of the welfare committee and further actions are beyond the court. If a settlement is reached between the parties, they can go to the High Court under 482, but the District Family Welfare Committee cannot make a non-compoundable offense compoundable by its own discretion, merely on the fact that the parties are agreeing, because the parties cannot agree in a non-compoundable offense without the High Court permission, where the High Court quashes the proceedings or any other order. Now the situation is still the same. In cases of false implication or in cases where the female wants to retain the marital relationship and wants to take back her complaint, there is no alternate provision. Moreover, talking about the offense of adultery. There was an offense of adultery in the Indian Penal Code. At a later stage in the year 2019, this adultery offense was decriminalized in the judgment Joseph Shine versus Union of India. The Supreme Court has struck down Section 497 on the grounds that it violated Article 14, 15, and 21 of the Constitution. And it was a very, very, I will say, emotional statement that was given by one of the judges out of this 5 judgments, who said that wife is not a cattle, wife is not a property of a husband. She cannot be treated as a property, because this particular provision, it was related to the penalization or taking criminal action against a man who commits illicit sexual intercourse with the wife of another man. Though the court has said that the provision is gender, this violation of Article 14, 15, and 21 on the basis of gender bias and on the basis of personal liberty. But there were 2 alternates which were there with the legislature. Either to completely remove the section adultery 497 of IPC in the Bhartiya Nyaya Sanhita, which has been done. But there was another alternate. This another alternate was to make the offense gender specific. To save the institution of marriage, This could have been done that instead of completely removing section 497 of IPC or the offense of adultery, the adultery could have been made gender neutral. For example, if a man commits sexual intercourse with the wife of another man, or if a woman commits sexual intercourse with the husband of another man, can be penalized under the offense of adultery. Moreover, the spouse who is committing adultery can be also added as an abettor or abetment or a conspirator to that particular offense, so that marriage institution can be saved, criminal action can be taken, but there should be no gender partiality, bias, or specificness.
Ma'am,
So,
like license has been
these are
given
all
to
the
the members, male and females, to have the extramarital affairs.
exactly. We can say it alternatively. We can say it that now after completely removing the offense of adultery, the criminal law has clearly said now this is your personal liberty. We have nothing to do with this. You may have any extramarital illicit sexual intercourse out of wedlock, though it might be a ground for divorce. It is a ground for divorce still under this civil law, but we cannot penalize you on this context. So if we are not penalizing them on this context, on the other side, we are not open for so many other things legally, like giving equal status to relationships legally, like accepting the homosexual marriages. So only on one context we have shown a broader horizon, but on the other context, our laws are still very, very stringent, or I will say very conservative towards the societal norms. So this was all for today. So any one of you with any question, any discussion, any point of view, you're most welcome. Anything for it.
Any questions from the participants? Please raise your hand, or you can just unmute and have the conversation. And before anybody raises, I would like to ask if you. I would like to ask one question relating to community service, ma'am. First of all, there are two considerations on the community service. Also, it's a welcome step, but if we have the consideration of security of the people, because under criminal laws, social defense is the first priority. So, in a vogue of rehabilitating these people, are we not given the security of the people at stake? That is one.
Okay.
And secondly,
Okay.
it's not properly defined as to what type of community service. It needs little bit clarity. Uh,
Right.
what can you say about this, ma'am?
Right. Your question is in two parts. I'll answer it in the two parts also. So the first part is related to the safety. I'll address the second part first, right? Because when you're talking about the definition of the community service or any specific inclusions or exclusions, that these are the acts which can be a part of community service, it has completely been given to the discretion of the courts that what kind of community service they will give to that person, right? So in that situation, I will completely agree with you that definitely the community service has not been defined, and since it is a newly introduced form of punishment, without defining it, we have different types of judges. Some judges who take a very, very strict viewpoint, some judges who are very much lenient, some judges who take the things very lightly, some judges who take the things very, very seriously. So for the same offense, the judges may vary in such a way that ultimately it may lead to, first of all, discrimination, and secondly, it may lead to a state of chaos, or I will say confusion, that what exactly that person needs to serve. So definitely the community service, through an explanation, rather the point which you have raised, many scholars have raised this particular point.
Should not be an easy let off, ma'am.
Yes, it has to be explained, well defined, that what are the different acts that can be included in the community service instead of leaving them on the discretion of the courts. Now talking about the first part of your question, where you are saying the safety of the public is in, I will say, on stake. So here I will vary a little from your point of view, because if you see, all the offenses for which the community service has been prescribed are not that serious in nature. For example, defamation. For example, the one who is committing a suicide, attempt to commit suicide, harming himself. So in that case, since the offenses, the nature of these offenses are not very severe, these are not very hardcore criminals. The
Yeah.
purpose of inserting this form of punishment is for their rehabilitation, and the reason being is that they have more chances of reformation than other criminals. So by repentance, by serving to the community, they may get involved emotionally and socially with the community, and they may have a better chances of reformation. So I don't think so that it will create any public safety issues.
Yeah. Yes, ma'am. That might be the noble vision for advancement of rehabilitation of people.
Yes, yes. And secondly, whenever this community service is taken by the people, definitely it will be under certain supervision. There might be some persons who will be accountable in whose custody that person has
After
been
that,
sent. So in such a situation, the safety might not be an issue, but definitely the undefined definition can be an
yeah.
issue.
Yes, yes. Yes. Thank you, ma'am.
Yes. Any other question? Thank you. Thank you so much. Any other question?
Madam, my question is,
Yes.
myself, Advocate Ashish Bajpai,
Yes, sir. Hello, sir.
facing,
Very nice to meet you.
glad to glad to listen you, madam.
Thank
My
you so
question
much.
is, it is criticized that these three enactments have been passed without following the procedure prescribed. What is your opinion about that?
So you have asked I must say, a very, very controversial question. But right now, as I am addressing this question as an academician, so definitely I will give a very, very clear or an honest opinion. When we are talking about the passing of these acts, you are right. It has been always alleged that these acts have been passed in haste. And when we are talking about the following of a specific provision, first of all, if you see the recommendations of the Law Commission of India, the Law Commission of India has never recommended to completely repeal the three acts. Secondly, the committees which are then formed. The committees are formed. That is a very, very big decision when we are overhauling the criminal laws of the entire country. The whole three acts have been completely repealed instead of doing any of the amendment. If you see the framing of the committees and the experts, though the experts were actually the law experts and criminal law experts and have given a very, very clear recommendations in the committee, but still, if you see I will not take the name of the persons because it will be a little, it might be a little not right on this platform. But if you yourself will read the name of the persons, you will keep on seeing that the persons have been shuffled, or I will say changed after few months, then after few days, and the committee kept on shuffling for a certain period, and after that immediately the decision has been taken by the government that now these are the three new bills, and we have presented it in the this House of Parliament, and all the three old acts will be repealed from so and so date. Then I cannot say or I cannot contradict your point that the bills have been passed in haste. Definitely they were. But if you see the this content, or if you see the provisions of these acts which have now been evolved, have now been enacted and have become operative. So in that case, we cannot say or point out any such provision which is practically making any harm or I will say affecting the interest of the common man or any person once these acts are becoming operative. So though passed in haste, but we cannot point out any very specific mistake which has been done because of this haste. So definitely legally the process has been followed. The bills have been passed in both the houses. They have got the assent of the president. So technically we cannot challenge the legality of these acts.
Thank you, madam. Thank you.
Thank you, sir. Yes, any other person, any other question?
Yes, ma'am. Myself, Vijay. So I would
Yes,
like
sir.
to ask one question, rather your opinion. We are having a
Yes.
tradition of Gandhian protest, fasting unto death. If such a kind of protest is being done from today onwards against the administration, would it be falling under the newly amended law.
As an offense.
Yes, it is. It is. It may be treated as attempt to commit suicide.
So why we are only pointing the newly amended law? If you see the previously this operative law, the Indian Penal Code, the same provision is there, section 309. So it will be an offense under 309 also, but on certain conditions. Because if you see the this crime, it can be a wrongful act. Act contains omission. A willful omission of not containing or not this consuming any food, any water in any way for a prolonged period, it will definitely bring a result of death. And since attempt to commit suicide, rather committing suicide is not permissible under law, rather our article 21 itself states that right to life does not constitute right to die. Rather, we are not even legalizing the process of euthanasia. So at such a situation, if a person is fasting at such a in such a stage or in such a way that it may affect him medically and it may ultimately lead to death, first of all, the authorities, they try to take that person forcibly to the hospital. They though the person is not consuming any food or any liquid item, but what they do through this by using the medical procedures, they try to give him nutrition. And otherwise, if the person is forcefully doing it, this is definitely attempt to commit suicide.
Ma'am, I have one question.
Yes.
I mean, Article 19 of the Constitution, has given you right freedom of speech, expression. So protest is also one of my fundamental right. But a way
Right.
of protest, suppose I'm blocking road for 10 days and 15 days. I'm not allowing public to use that way. And if it is causing nuisance to the common man, then it is punishable under new act or not.
If you remember the provisions under IPC related to wrongful restraint. So whatever you are saying comes under the provision of wrongful restraint. Wrongful confinement and wrongful restraint, word to word, are still same under the newly constructed act, which the way they were in the previously constituted Indian Penal Code. And secondly, when you are saying the freedom of speech and expression, the freedom of speech and expression is subject to certain limitations, certain restrictions. Your freedom must not curtail the freedom of another person. If you have a freedom of speech and expression, that person is also having a fundamental right, that is freedom to move freely throughout the territory of the country. So in that case, this was an offense under Indian Penal Code. This is an offense under Bhartiya Nyaya Sanhita. Any other question? Any other query?
नो क्वेश्चन मैम। शेफाली मैम, पहले तो मैं हिंदी में बोलूँगा। मैं शेफाली मैम, मैं पटना बिहार से जुड़ा हुआ हूँ और हमारी पढ़ाई पत्रकारिता से संबंधित हुई है। मैंने कभी लॉ की पढ़ाई नहीं किया, मगर पत्रकारिता क्षेत्र से जुड़े हुए होने के कारण हमेशा लॉ की जानकारी हमेशा रखनी पड़ती है, क्योंकि बहुत सारी बातें ऐसी होती है जो एकदम जरूरी होती है। आज पूरे देश में एक नए आपराधिक कानून के तहत में मतलब कार्यक्रम चल रहा है, थाना में भी चल रहा था। तो हमें आज ये प्रोस्पेक्टस मिला था थाना से, जिसे पढ़ने के लिए कहा गया था। मैं पढ़ रहा था और काफी देर से आपके बातों को सुन रहा था, आपने प्रेजेंटेशन दिया। मैं इसे पढ़ने के बाद मुझे लगा इसमें मोटा मोटी बातों को तो सिर्फ दर्शा दिया गया है, लेकिन मुख्य चीजों को नहीं दर्शाया गया। और जब आपका मैं शेफाली मैम सुन रहा था तो मुझे लगा, और शायद ये यूट्यूब के माध्यम से मुझे लिंक मिला। पूनम मैम से मैं वाकिफ हूँ और पूनम मैम के माध्यम से कोरोना काल से मैं जुड़ा हूँ और कई सेशन में। तो आज संयोग था कि चैनल पे सब्सक्राइब कर रखा था, नोटिफिकेशन आया, तो मुझे लगा कि मैं यूट्यूब से जुड़ूंगा तो उसमें मुझे कोई लाभ नहीं हो पाएगा। पहले शेफाली मैम, आपका मैं पहली बार पूरे कोरोना काल में, अभी तक आपसे हमारा कभी रूबरू नहीं मैं हो पाया था, मगर आज आपकी पहली बार से ना सेशन आपने इतनी बारीकी से, इतनी अच्छे तरीके से नए कानून के बारे में आपने बताया कि मैं अगर उस लिंक, यूट्यूब लिंक को मैं अगर आने मतलब मेरा जो चैनल है उसमें मैंने शेयर भी किया है, कई लोग उससे जुड़े भी हैं। तो मुझे ये अच्छा लगा कि कम से कम आपने बारीकी, जो मेरे मन में कुछ सवाल आ रहे थे इसे पढ़ने के बाद, आपने उसे सही डीपली तरीके से आपने समझाया। और वो भी मेरे लिए एक इतिहास होगा ये आज का दिन, क्योंकि आपसे मुझे जैसे आज का दिन कानून लागू होता है उसके बाद मैं शेफाली में सिर्फ मैं आपका सुनकर मुझे अच्छा लगा इस चीज के लिए। और एक कहावत है ना कि बिन गुरु के ज्ञान नहीं होता है। तो हम कितना भी किताब उठाकर क्यों ना पढ़ लें, मगर जब तक गुरु का आशीर्वाद नहीं होगा, गुरु का साथ नहीं होगा, गुरु का मार्गदर्शन नहीं होगा, तो हम कुछ भी नहीं हो सकता है। तो शेफाली मैम, आपका बहुत बहुत आभार, आपने मुझे इसके बारे में बारीकी से समझाया। पता नहीं फिर मुलाकात आभासी माध्यम से हो ना हो ये, लेकिन एक चीज है, एक शिष्य है जो आपके सामने बैठा है आभासी माध्यम से, जो पटना का है, ये बस याद रखिएगा, क्योंकि मुझे अच्छा लगा, एक नया मार्गदर्शन मिल पाया। आज जो जान पाया मैं कोशिश करूंगा, जो मैंने व्यू पॉइंट को मैंने नोट किया है डायरी में, उन लोगों को मैं समझाने में भी सक्षम रह पाऊं, क्योंकि लोगों में अवेयरनेस की जरूरत है। पिछला भी जो कानून था, बहुत सारे ऐसे लोग होते, ग्रेजुएशन तो कर लिए, मगर उनके वो लोग मतलब उन लोगों के पास भी थोड़ी सी भी कानून की जानकारी नहीं है। तो मैं लॉ के भी जो विद्यार्थी यहाँ जुड़े हुए हैं, मैं उनसे भी गुजारिश करूंगा कि आप कोई भी कानून जो होता है, अगर आप मोटा मोटी भी अगर लोगों के बीच में एक अवेयरनेस कर पाएंगे, तो मुझे लगता है कि हर लोग उतने जागरूक हो पाएंगे, लोगों के बीच में एक अच्छा माहौल क्रिएट हो सकता है, लोग भयभीत नहीं हो पाएंगे। तो मेरी कोशिश है मैम कि इस तरह का सेशन अवश्य, पुनः मैम से भी गुजारिश है, लगातार करवाएं ऐसे सेशन को, और ज्यादा से ज्यादा कोशिश हो कि गूगल मीट के माध्यम से हो, क्योंकि मैं बराबर यूट्यूब पर देखता हूँ लाइव, गूगल मीट पे बहुत कम होता है कार्यक्रम। और ये अच्छा लगा शेफाली मैम, आपसे मिलकर, आपके साथ जुड़कर कुछ जानने को मिला। बहुत बहुत आभार।
धन्यवाद सोनू जी। सबसे पहले तो मैं आपकी शुक्रगुजार हूँ कि आपने हिंदी में बात करी। मैं सोच ही रही थी यहाँ पर कि क्योंकि मैं महाराष्ट्र के ज्यादातर लॉ कॉलेजेस में इस वक्त ये एड्रेस कर रही थी, तो पता नहीं हिंदी एक सही माध्यम रहेगा साथ के साथ ट्रांसलेट करने का, या सिर्फ मुझे अंग्रेजी में ही कहना पड़ेगा। पर चलिए, मैंने अंग्रेजी को इसलिए चुना कि सब लोग आराम से समझ पाए, कोई बीच में हमारे कोई लैंग्वेज का बैरियर ना आए, कोई भाषा का कोई बीच में इस तरह की कोई बैरियर ना आए। लेकिन जैसे आपने दूसरी बात कही कि आप पत्रकारिता से जुड़े हैं और आपका बहुत ज्यादा लॉ के साथ वास्ता होता रहता है, बिल्कुल, ये बिल्कुल सही है। बल्कि मैं आपको एक बात कहना चाहूंगी, आप ही को नहीं, मैं सभी लोगों से एक बात शेयर करना चाहूंगी कि ये जो नए क्रिमिनल लॉज आए हैं, इनमें क्या है कि हम जो वकील लोग हैं या जो वकालत से जुड़े लोग हैं, लॉ अकेडमिशियंस हैं, हम तो इन्हें पढ़ रहे हैं, लेकिन आम आदमी को नहीं पता चल रहा है कि क्या फर्क पुराने लॉज में था, क्या फर्क नए लॉज में है। इसलिए वो अगर प्रोटेस्ट भी करेंगे तो कैसे करेंगे, वो तो इसके बीच का फर्क ही नहीं समझ सकते। सेकेंडली, हमारी अगर आप क्रिमिनल लॉ का सिस्टम देखें तो कहीं ना कहीं इसमें बहुत बहुत ज्यादा हमें एक दिक्कत भी आने वाली है। अब दिक्कत ये आने वाली है कि इस वक्त इंडियन पीनल कोड अगले 15-20 साल तक पैरेलली चलेगा, साथ के साथ चलेगा आपके भारतीय न्याय संहिता के साथ, क्योंकि जो केसेस ऑलरेडी दर्ज हो चुके हैं या जो भी कॉज ऑफ एक्शन आज से पहले तक है, वो सारा इंडियन पीनल कोड के अंदर, क्रिमिनल प्रोसीजर कोड के अंदर और इंडियन एविडेंस एक्ट के अंडर ही आएगा। तो ऐसे में सारी की सारी कोर्ट्स को ये सारे प्रोसीजर्स पैरेलली चलाने पड़ेंगे, वकीलों को तैयारी पैरेलली करनी पड़ेगी, स्टूडेंट्स को दोनों ही एक्ट्स पढ़ने पड़ेंगे, जबकि सिलेबस में हमने चेंज कर दिए हैं, सिर्फ नए एक्ट्स रखे हैं। ऐसे में जिम्मेदारी है हर एक गुरु की और हर एक लॉ से जुड़े व्यक्ति की कि वो इनके बारे में जितनी बात हो सके उतनी बात करे, ताकि इसके कंपैरिजन को सब आम आदमी तक पहुंचा सके। बाकी आपको बहुत धन्यवाद, आपने बहुत बड़ी बड़ी बातें कही हैं, अभी इतनी बड़ी मैं हुई नहीं हूँ, पर आपको बहुत बहुत धन्यवाद जी। हाँ जी, anyone else, anything else from your side? Yes, Ritika Nayak has raised a hand. I think she wants to say something. Okay, might not be.
Madam, still we all feel that instead of repealing this act, some modification would have done through amendment, even changing the name also if we need. Though we are saying that instead of penal law, it is the Nyaya Sanhita, but more stringent, in fact, more stringent punishments have been given now in new BNS, madam.
Yes, I will completely agree with this viewpoint. In fact, from last 1 year, when this the bill has come into the picture and it was discussed, continuously I was discussing the same thing in the class. Then instead of 3 new acts, there can be a Criminal Law Amendment Act 2023 or a Criminal Law Amendment Act 2024. Because specifically, even if you see in the Indian Evidence Act and the Criminal Procedure Code, very few changes have been done. भारतीय न्याय संहिता में तो फिर भी बहुत सारे चेंजेस आए हैं. IPC has changed quite a lot, but CRPC and Evidence Act, Evidence Act completely is a reshuffling of the provisions except 3 or 4 provisions. So in that case, instead of creating this chaos, it could have been an amendment, but it could have been an amendment. Otherwise, the acts have been enacted, and we have to go with the flow. We have to go with the this whatever the decision the parliament has taken. Yes. Anything else from anyone else?
Any other questions, or shall we proceed?
Thank you, ma'am. Hello, ma'am.
Yes, sir. Please go ahead.
Yes, please.
Myself, Gopal Panchal from Dayanand College of Law. Ma'am, I have one doubt with regard to this sixth kind of punishment, community service is concerned. While passing sentence by the magistrate or a judge, there is possibility of committing discrimination among the culprit who are convicted. A person from high class society, he may be ordered to plant the trees. Or a poorer guy, he may be asked to go for sanitization. So what is the solution then? Is there any solution that discrimination between richer and poorer may be curbed? Is there any existing solution is available under the Nyaya Sanhita?
Yes.
Please.
Before answering this question, first of all, I would like to just ask one thing from you: that are you considering this community service as a better punishment for an offender, or you are considering this community service as a worse punishment for the offender? First of all, how are you taking this community service? कि अगर community service as a punishment दी गई है, तो वो offender के लिए अच्छा हुआ है या बुरा हुआ है?
No. अच्छी बुरी की बात नहीं, बात यह है कि judge shall not make discrimination.
जी. Because
there is a probability that the discrimination may be practiced.
Because the kind of discrimination you are pointing out, I agree with that part. I will give you another example of discrimination where the community service has been given to a person who was from a very influential family or a very influential this background, just to give a lighter or a less severe punishment. If you see the example of that recent Pune car accident case, that drunk and drive case, this boy who was a minor, who was drunk, who has killed another person because of this rash and negligent driving, and that through too under the effect of intoxication, and he was underage. He was not even permitted to have a driving license. So in such a situation, he has been given, though at that time this was not applicable, but by the lower court, he has been given to write this essay on this road safety, and that was the punishment which was given to him as a reformative measure. And it was contradicted, it was criticized on the grounds that since he belonged to a very, very influential background, the judge has done this discrimination. Now, taking the second part that you are pointing out, you are saying that if a person is from a lower economic strata or a lower social strata, in such cases, there is a possibility that he might be given to do certain menial jobs in the form of community service, which will highlight him more according to his social status and class, which is actually not right as a punishment for crime, right? So in that case, this particular discrimination clause, or this discrimination, the apprehension of discrimination, it is not only in the this in terms of community service. For that reason, we can also say that the judge may discriminate with these persons, may give them very harsh punishments, may refuse bail to them, but will give bail or this lighter punishments where the bar is so, I will say a very big bar like 0 to 7 years, 0 to 10 years, the judge will reduce the quantum of punishment if the person is from rich segment. So on the basis of apprehensions, we cannot criticize or we cannot point out that the community service is not a right kind of punishment. But definitely there should be measures to face the challenge if certain any cases of such discrimination are seen, because once the lower court has done this discrimination, we still have remedies in the higher hierarchy of the courts. And secondly, we can only come to the exact conclusion once these are implemented. Then we can see that what kind of punishments are given by the judges. Secondly, whether the judges are discriminating on the basis of any class difference or community difference, or it is not being done. So I think it will be a little premature stage to criticize it on the basis of an apprehension. Though your
Yeah.
apprehension may prove to be right, but once it is proved right, it has to be seen that whether such challenge can be met or some new provision needs to be inserted for that.
Mean appeal is the remedy, and
Yes, sir.
in eventually, time will give us the approach. Accordingly, law will be updated. This is the
Yes, yes.
premature stage. Okay,
Yes,
okay.
exactly.
Thank you,
This is
ma'am.
what I'm saying.
Thank
This
you.
is a
Thank
little
you very
premature
much.
stage.
Yeah.
Yes, any other question? Any other query?
अनम्यूट कर लें मैम, अनम्यूट कर लें।
Anji?
सुनो मैम।
Yes, yes. Ma'am, much of your time is taken by us, but we can take one last question
Definitely, definitely. Please.
if anyone it is there. Yes, ma'am. I think as the whole session was very much thought provoking, ma'am, many questions are still in their mind, and we are just sharing our this thing, the whole information which you have given, and it was such a nice lecture, ma'am, because the whole different provisions were dissected and their legal implications were also explained by you. It was really very thought provoking, engaging, and a very nice experience to have this lecture, ma'am. So I would like to request, going further, I would like to request Dr. R.B. Deshmukh, sir. Thank you, sir. Kindly propose a vote of thanks because are you? Yes, sir.
Yes. I'm audible, ma'am.
Yes, sir. You're audible. Dr.
Okay,
R.B.
okay.
Deshmukh, sir, is principal of Shri Shivaji Law College, Parbhani. Yes, sir.
Okay, thank you, ma'am. Thank you. Honorable resource person, Dr. Shaifali Dixit, ma'am, principal of Dayanand College of Law, Latur, NC Law College, and Shivaji Law College, Kandhar. Participants, law faculty members of different law colleges. I, Dr. Rajesh Deshmukh, in charge principal of Sri Shivaji Law College, Parbhani. I am here to convey vote of thanks. Firstly, of all, I would like to convey vote of thanks to Dr. Shaifali Dixit, ma'am, Himachal Pradesh National Law University, Shimla, for gracing the national webinar as resource person. I also extend my vote of thanks to the SRTMU as well as Dean Dr. Parag Khadke sir for their kind help and encouragement. I convey my vote of thanks to coordinator Dr. Poonam Nathani ma'am, Dr. Veena Patil ma'am, Dr. Manoj Dharmapurikar sir, as well as office bearer of all law colleges for their great efforts and guidance. I equally convey vote of thanks to all participants, law faculty members of different law colleges for making this webinar successful. Lastly, I convey vote of thanks to all who have directly and indirectly helped to make this event successful. Thank you so much, ma'am, for your excellent presentation.
Thank you so much, sir. And it has been really, really a great experience while delivering this lecture and a presentation. I would really like to thank Dr. Poonam Nathani ma'am for inviting me for this session. And moreover, I would also like to thank the organizing committee and all the office bearers of Dayanand Law College of Latur, NC Law College Nandad, Shivaji Law College Prabhani, Shri Shivaji Law College Kandhar. And I would also like to thanks all the participants for such a patient listening and moreover asking the questions, interacting with us. It really made the session more fruitful. Your contribution was much needed. Thank you so much, all of you, for inviting me and considering me wise enough to give this lecture and to interact with all of you. It was a great experience for me. It was really a great experience for me.
Thank you very much, ma'am. And this is the only first occasion, but we'll be continuing with your collaboration, and we'll really hope that in future also we'll have the academic collaborations on various other topics.
Yes,
Thank
yes,
you. It
yes,
was very
definitely.
nice.
My pleasure. In fact, if any participant wants my number, you are free to share the number with them.
Thank you. Thank you so much, ma'am. I'll be sharing it in the chat so that participants can have their contact. Also, one more important thing, that the feedback link of this particular webinar that will be also shared in the chat, because we'll be requiring the feedback, the valuable feedback for all the participants. I'll be
शेफाली
sharing it
मैम
in the
आप
chat.
शेफाली मैम आप फिर से चैट बॉक्स में अपना नंबर शेयर कर दें ताकि मैं आपसे जुड़ा रहूं, और कभी मुझे अगर जरूरत पड़ जाए तो मैं आपके व्यक्तिगत व्हाट्सएप पर मैं मैसेज कर लूंगा, कोई अगर इस तरह का सवाल होगा तो।
जी
क्योंकि
जी।
सबसे ज्यादा जरूरी आम जन के साथ, आपने सही कहा मैम, आम जन के साथ सबसे ज्यादा असुविधाओं का खेद होता है, क्योंकि उनके पास जानकारी नहीं हो पाती है, और वो इन तमाम चीजों के बारे में अगर उन्हें बताया जाएगा, छोटी छोटी बातों को अगर मैं दिन भर में 10 पॉइंट अगर कानून से संबंधित उन्हें सलाह अगर मिलता है तो मुझे लगता है कि उन्हें कोई पढ़ा नहीं पाएगा, कि कोई कितना भी क्यों ना आ जाए। लेकिन हकीकत है कि हम लोग तो लॉ लॉ जर्नलिज्म पता नहीं करने वाले कुछ लोग हैं जो कुछ सोच करके इस लाइन में आते हैं कि कुछ करके जाना है, कुछ करके दिखाना है, मगर हकीकत जाने के बाद पता नहीं बदल जाते हैं लोग। मैंने ये इन चीजों को भी देखा है, मगर मैं उन लोगों से कहना चाहता हूँ बस इतना ही कि
मैंने मैडम
कुछ
का नंबर
बेहतर
शेयर
करना है, राष्ट्र हित में, जनहित में होते रहना चाहिए काम, और ज्यादा अच्छा लगता है। तो शेफाली मैम, आज आपका मार्गदर्शन मिल पाया, मुझे तो बहुत खुशी है। और पूनम मैम से मैं गुजारिश करूंगा कि इस तरह का सेशन अवश्य करवाएं पूनम मैम, और हम लोग अवश्य जुड़ना चाहेंगे। और कोशिश कीजिए क्योंकि गूगल मीट पे ही करवाने का, क्योंकि आपका कार्यक्रम होता है कि कोई और प्लेटफॉर्म है जहाँ मतलब वक्ता ही जुड़ पाते हैं, उसमें हम लोग जुड़ नहीं पाते हैं तो सवाल भी नहीं कर पाते हैं। तो इसलिए प्रत्यक्ष आभासी माध्यम से अगर ये माध्यम रहेगा गूगल मीट का तो ज्यादा अच्छा रहेगा। धन्यवाद।
मैंने चैट बॉक्स में मैडम का नंबर शेयर किया है, और इवन फीडबैक फॉर्म की लिंक जो है वो भी शेयर कर दिए। तो मैं आई विल लाइक टू रियली रिक्वेस्ट एवरीवन टू काइंडली फिल अप द फीडबैक फॉर्म, so and you'll be getting the e-certificate of this webinar. Okay, with the permission of respected sir and all the respected principals, I would like to declare that today's session we are stopping today, but also this will be continuing in the future. So today's session is over. Thank you very much. Thank you.
Thank you. Thank you
Ma'am.
all.
Thank you, ma'am.
पूनम में लिंक नो ओपन, लिंक नहीं खुल रहा है।